Number 3, pitfall 3, failing to fund a trust. I just mentioned that with a revocable living trust, you will have a will too. Why? A revocable living trust is intended to avoid a probate. But what happens, especially if you do it yourself, and even if you had an attorney help prepare it, is an essential step of a revocable living trust that works as intended is that the trust is funded. And you might say, I did not know I need to fund the trust. Nobody told me that. My lawyer didn't help me fund the trust. So what I want you take away is if you have a revocable living trust and if it is the correct form type of dispositive document that works on your death for you, it has to be funded. How do you fund your trust? Well, some things are simple. You fund your trust by changing the name of your bank account. So let's say your bank account is, Fred Smith. Okay. Now you have a trust. And now, Fred Smith, you are the trustee. So it's now Fred Smith as trustee of the Fred Smith Revocable Living Trust, which is a little bit confusing because you did not need to get you like a tax ID number. You can use your social security number for your revocable living trust bank account. And you created the trust, so you're the trustor and you are the person in charge of the trust, so you're the trustee, and the trust is for your benefit, so you are the beneficiary. So all of these hats, all of these roles are just in the one person who created the trust. So it gets a little confusing and misleading to think that, oh, I have to change all my bank accounts into the name of the trust. Yes, you do. What if you have a house? That has to be retitled into the name of the trust. And so any real property requires a deed. Typically, it's a quitclaim deed from Fred Smith to Fred Smith as trustee of the Fred Smith Revocable Living Trust. Has to be filed with the county. Filing fees have to be paid. That work has to be done. And then let's say it's properly funded with those items. If you get any new bank accounts or any new real property, same thing has to be done, same form, have to put it in the name of the Revocable Living Trust. Commonly, there is something that is forgotten, some sort of orphan account. It's not put in the name of the trust. So what happens then? And assuming that the bank account is of a large enough size, it's over 100,000 in the state of Washington, then there needs to be a probate. That's where that pour over will came in, because you planned to avoid probate, but a mistake was made. Commonly, a mistake is made in funding. And so there is a probate where the orphaned asset, the one that's outside of the trust, is captured, brought through the probate into the trust so it can be distributed as intended. So failing to fund a trust properly is pitfall number 3. It's very, very common. So a revocable living trust can be an excellent planning tool, but it has to be properly administered throughout the lifetime of the person who created this trust. So it's not a one and done thing. It goes on and on until that person dies. So talking about whether or not the revocable living trust is the proper tool, we'll talk about that in I'll give you a couple of different examples. One example that I thought was particularly egregious that I saw was a revocable living trust was prepared for a single man, and he had no kids. He had a lot of nieces and nephews, and one that he favored in particular. And he had a very simple estate. He had one bank account and he had one house, and he really did what he thought was the right thing. So he had a trust, and he said that on his death, everything goes to the one nephew. And it would have been a great plan had he funded this trust, which he did not. And so, and apparently, and I looked to the attorney whomever drafted it, why didn't they help their client? Why didn't they do the quick claim deed? Why didn't they give instructions? I don't know. But this is an example of how a trust can fail. So what happened in this case was there had to be a probate, and a lot of reasons why people want to avoid probate is they don't want to give notice of the probate to all the people who get notice. And so if a single man with, 12 nieces and nephews, they all need notice that there was a probate so that it could go to the probate requires notice to the heirs at law, not just to beneficiaries of a trust, but to heirs at law. 12 heirs at law needed notice just to capture the asset, put it back into the trust so that it could then be distributed to the one nephew who may not have been everybody else's favorite nephew after they realized that the uncle gave everything to him. So the key takeaway in this pitfall is that a trust is only as good as the assets that are placed into it. It must be funded.